Okay, so we're diving into this ascertaining loss and expense document that you sent over.
Right.
It's the second edition from the Royal Institution of Chartered Surveyors.
RCS.
RCS. Yeah, pretty fresh off the press from July 2024. We're going deep into construction contract territory here.
Yeah.
Especially those situations where a project hits a snag.
Right.
And someone needs to figure out who's on the hook financially.
This document is essential reading for anybody that's in that position, you know?
Yeah.
Think of the surveyors and the lawyers and the project managers,
Right.
even the contractors themselves. Anybody who wants to understand how to navigate these financial minefields when things go wrong.
It's kind of like a financial detective story, right?
It is.
We're looking at these loss and expense claims,
Yeah.
which basically boil down to requests for compensation.
Yeah.
When unexpected stuff causes delays or blows the budget.
That's right. And they go way beyond just the initial contract price. You know, they dig into all the ripple effects,
Right.
the delays, the disruptions, those unforeseen circumstances that can just throw a project's budget into total chaos.
So this RICS document is meant to guide people through that process.
Right.
It's packed with info on different contract types,
Yep.
real court cases, even tips on building a strong claim.
Yeah.
What I find really interesting is that it's not just about the technical stuff.
Yeah.
It touches on how to manage risk, negotiate effectively, even understand all the nuances of construction law.
Yeah, that's a great point. Understanding loss and expense is bigger than just seeking compensation.
Yeah.
It's about building a culture of transparency and accountability
Okay.
and proactively managing risk in the construction industry as a whole.
So let's start with the basics. What exactly are we talking about when we say loss and expense claims? What kinds of situations trigger them? And how are they different from typical contract damages?
So a loss and expense claim arises when a contractor faces extra costs or losses directly because the employer breached the contract or something happened that's not the contractor's fault. This is where it differs from typical contract damages. Those are usually fixed amounts agreed on in the contract itself.
Yeah.
Loss and expense claims aim to cover the actual losses the contractor had to eat.
Okay. So let's say a contractor hits unforeseen ground conditions, like a hidden water table.
Right.
That wasn't in the original contract.
Right.
That could be grounds for a loss and expense claim.
Right? Absolutely.
Yeah.
So that scenario, you've got more work, more resources impacting both the timeline and the budget. The contractor could then file a claim to recover those surprise costs.
Okay.
Now, this guide really dives into 3 specific types of contracts.
Yeah.
The JCT standard form,
Okay.
the NEC engineering and construction contract, and FIDIC contracts. Each of these has its own quirks when it comes to handling loss and expense.
Okay. So let's break down some of the key differences between those contract types.
Sure.
Especially what you need to do to make a successful claim.
Right.
Let's start with those JCT standard form contracts. What are we looking at there?
So with JCT contracts, there's a couple of important things a contractor needs to do to make a loss and expense claim.
Okay.
The first is they have to notify the employer as soon as they realize they're likely to incur loss and expense.
Right.
Transparency and early communication are key here.
That makes sense. You can't just spring a massive claim on the employer out of nowhere.
Yeah.
They need time to assess the situation, maybe even prevent further damage.
Exactly. And the second condition is that the contractor has to give the employer details of the loss and expense pretty quickly.
Okay.
We're talking about supporting the claim without overwhelming them with paperwork.
So how pretty quickly does the document give a specific time frame?
It uses the phrase reasonably promptly, which is open to interpretation.
Okay.
But the document really hammers home the importance of submitting that claim without unnecessary delays.
Yeah.
There's a court case, Walter Lilly and Company Limited v. Giles Mackay and DMW Developments Limited back in 2012 that helps clear this up a bit. It stated that the contractor only needs to submit enough detail to support their claim.
Okay.
Just the essentials.
So there's a balance to be struck.
Yeah.
It's about giving enough information to back up the claim, but not drowning the employer in a sea of paperwork.
Exactly. And speaking of Walter Lilly, that's one of several real-world cases we can look at to see how these principles play out in real life. It gives you insight into legal precedents and how judges interpret these complex contract clauses.
Let's dig into that Walter Lilly case then. It sounds like a landmark case for anyone dealing with loss and expense. What were some of the key takeaways, especially for people working with JCT contracts?
Walter Lilly offered some crucial insights into how those loss and expense claims are assessed under the JCT standard form. The judge basically said the contractor only needs to submit enough detail to allow the architect or quantity surveyor to form an opinion. Has regular progress been affected by something irrelevant? It's about proving the event's impact on the project.
So you need solid evidence, but it's not about dumping every single detail right away.
Right.
You need to demonstrate that the event impacted the project's progress.
Precisely. And this case also emphasized that you don't need to submit every single detail up front.
Right.
There's a degree of flexibility there.
Okay. What other real-world cases offer helpful insights? Did the document mention any other noteworthy examples?
It certainly did. The document touches on a range of cases highlighting different aspects of loss and expense.
Yeah.
Take WW Gear Construction Limited v. McGee Group Limited.
Okay.
This case highlights the importance of sticking to notice provisions in these contracts.
Okay.
Missing a deadline or failing to submit a notice on time.
Yeah.
That can seriously jeopardize a contractor's claim.
So meeting those deadlines and following those notice procedures is absolutely crucial.
It is.
It's not just about the claim itself, but the process leading up to it.
Exactly. These cases emphasize the need for meticulous record-keeping attention to detail and a solid grasp of those contract clauses.
Right.
They offer valuable lessons that can prevent costly mistakes down the road.
It seems like those legal precedents can be just as valuable as the contract clauses themselves. They give you real-world context and clarity on how these provisions are interpreted and applied.
I couldn't agree more. They offer a practical understanding that can help avoid those financial pitfalls. Now let's shift gears to the NEC Engineering and Construction Contract,
Okay.
or NEC for short. How does it handle loss and expense?
From what I understand, it takes a slightly different approach than the JCT.
Okay.
It's all about being proactive rather than reactive, encouraging a collaborative approach to resolving those issues.
You've hit the nail on the head. The NEC contract is big on early warning notices and risk management.
Okay.
Contractors need to flag potential issues as soon as they pop up.
Yeah.
This gives the employer a chance to address the problem before it snowballs into a major claim.
Right. So let's talk about those compensation events. Yeah. What exactly are they, and how do they differ from the relevant events we see in JCT contracts?
Compensation events basically give the contractor the green light to claim extra time or money, or both.
Okay.
Think changes to the work employer caused delays even finding something valuable on site. The list is pretty comprehensive. Unlike JCT's relevant events, which are mostly about delays, NEC's compensation events cover a much broader range of situations that could impact the project.
So it sounds like the NEC contract offers a more structured, detailed framework for dealing with these situations.
That's a fair assessment.
All right, we've covered the basics of loss and expense and the different contract types.
Yeah.
Now let's get into the nitty-gritty of the costs themselves.
Yeah.
This guide isn't just about the obvious costs, materials, labor, and so on. It dives into trickier stuff like disruption and prolongation.
And that's where things get really interesting. We're talking about those hidden costs that often slip under the radar. The ripple effects that impact a project's efficiency and profitability.
Can you give us some examples of those less obvious costs and how they factor into a loss and expense claim?
Let's start with disruption. Imagine you've planned a concrete pour, but the rebar delivery is late.
Right.
Now your crew is standing around, your schedule is thrown off. Those are disruption costs adding up. It's basically anything that forces the contractor to work less efficiently or in a different order than planned.
Okay, I can see how that can quickly snowball into a lot of extra costs.
Right.
So how do you actually put a dollar amount on those disruptions for a loss and expense claim?
One method the document suggests is called measured mile.
Okay.
Think of it like tracking your running pace.
Mm-hmm.
You compare your speed on a familiar route to a new one to see the difference. It involves comparing the value of work produced during a disrupted period to the value produced in a similar non-disrupted period. This helps figure out the productivity loss linked to that event.
So if a contractor normally lays 100 bricks per hour, but only manages 80 during a disruption,
Right.
that difference helps calculate the productivity loss and how much that costs them.
Exactly. It's a way to measure the impact of those disruptions.
And let's talk about prolongation costs, another area that the document digs into.
Prolongation costs are what happen when a project is delayed, making it run longer and leading to more expenses for the contractor.
Okay.
Think of it as the cost of keeping the project alive for longer than you planned.
So if a project is pushed back 6 months because of unforeseen ground conditions, the contractor would rack up extra costs for things like site overheads,
Yeah.
salaries for an extended period, even the impact of inflation on material prices.
Exactly. Those costs can really pile up and impact the project's profitability. The document gives you a detailed rundown on how to calculate those costs, taking into account things like the specific contract clauses, the type of delay, and the records you have.
So understanding those prolongation costs is vital for both contractors and employers. Right, they can have a huge impact on the project's financial outcome.
Absolutely. That's why this RICS document is such a valuable resource.
Yeah.
It gives you practical tools and insights to navigate those cost considerations.
Speaking of practical tools, let's talk about building a strong loss and expense claim.
Right.
What kind of records are essential? How detailed should the claim be?
The document stresses the importance of contemporary records created as things happen.
Okay.
They're the most reliable evidence for your claim.
Yeah.
We're talking about things like site diaries, meeting minutes photos, daily work reports, even emails. They capture what was happening day to day, creating a timeline of what led to the loss and expense.
So it's about painting a clear picture of what happened and when backed up by evidence.
Exactly. The document emphasizes proportionality.
Okay.
Give enough detail to show the impact of the events on the project.
Yeah.
And allow the employer to understand your claim.
So it's about striking a balance between detail and clarity.
Right.
Not bombarding them with every single receipt,
Yeah.
but providing a clear and compelling story backed up by solid evidence.
Exactly. And the document even offers specific formulas like the Hudson and Emden methods, which can be used to calculate certain types of losses, particularly those related to head office overheads and profit.
That's incredibly helpful. It gives contractors concrete tools to build a robust and quantifiable claim. Now, before we wrap up this first part of our deep dive, let's touch on another critical aspect of CHEAP: mitigation of cost.
Yes. This principle is fundamental in loss and expense claims.
Yeah.
It essentially means that the contractor has a duty to take reasonable steps to keep those losses as low as possible.
Okay.
They can't just sit back and watch the costs rack up without trying to mitigate the situation.
So let's say a contractor experiences a delay caused by the employer.
Right.
They can't just keep working at their usual pace and claim for all the extra time and cost.
Right.
They have to explore ways to minimize the impact of that delay.
Exactly. They need to look at alternative work sequences, maybe adjust their resources, even propose solutions to the employer to speed things up. It shows they're being proactive and trying to protect everyone's financial interests.
What happens if the contractor doesn't take those reasonable steps to minimize the losses?
Well, the employer could argue that the contractor could have minimized some of the impact through proper mitigation efforts.
Yeah.
This means the claimed losses are not entirely their responsibility, which could reduce the amount the contractor can recover.
So it sounds like mitigation of cost is not just a legal requirement,
Right.
but also a smart business practice.
Yeah.
It's about being proactive and taking responsibility for managing those costs.
Absolutely. It demonstrates a commitment to problem solving and protects everyone's bottom line.
This has been incredibly insightful.
Yeah.
We've covered a lot of ground in this first part of our deep dive, defining loss and expense, exploring different contract types, and delving into those often overlooked cost considerations. Where do we go from here? What can our listener look forward to in the next part of this deep dive?
We've seen just how important it is for contractors to understand those specific clauses and procedures for handling loss and expense claims, especially since they vary across contract types.
Right.
We've also learned that keeping detailed records and giving early notifications are essential for building a solid case. In the next part, we'll explore the pros and cons of various claim methods and dive deeper into the practical side of proving and managing these complex claims.
This is just the tip of the iceberg.
Yeah.
Be sure to join us for part 2, where we'll continue exploring the world of loss and expense claims in construction.
Right.
Welcome back to our deep dive into ascertaining loss and expense. Last time we laid the groundwork defining what loss and expense claims are and unpacking those tricky contract types like JCT, NEC, and IDI.
We also talked about the importance of those early warning notices, meticulous record keeping, and the contractor's responsibility to mitigate costs. Those are all key ingredients in a successful claim.
Absolutely. Now let's get into the nitty-gritty of proving your case. The document has some really useful pointers on this.
One thing it emphasizes is understanding the strengths and weaknesses of different ways to make a claim, There's no magic formula, and choosing the right method can make or break your claim.
Okay, let's break down some of those methods. What are some common ways to calculate and present these loss and expense claims?
One method we discussed earlier, especially for those prolongation costs, is the measured mile approach. It's about comparing the value of work done during a disrupted or delayed period to a similar period without those issues. This helps put a number on the productivity loss that's directly tied to the event.
Right, and it seems pretty straightforward when you have clear records of work progress and labor productivity. But I imagine there are situations where measured mile isn't the best fit, right?
You're right. It works best with tasks that are repetitive and easy to measure. When you've got more complex or varied activities, it's harder to set a reliable baseline for comparison.
So what are some alternatives when measured mile isn't the right tool for the job?
The document also talks about formulaic methods like the Hudson and Emden formulas. These are particularly helpful for figuring out losses related to head office overheads and profit. They consider factors like the contract sum, the contract period, and the length of the delay to estimate the hit to the contractor's overall profitability.
It sounds like those formulas help capture those costs that aren't always directly tied to specific on-site activities, but are still a real drain on resources.
Yeah.
But I bet there are also some drawbacks to using formulas, right? They might not always accurately reflect the unique circumstances of each project.
You've hit the nail on the head. The document cautions against using formulas blindly. They're a useful starting point, but you need to adjust them based on the facts of each case.
So it's about finding that balance using standardized methods while tailoring the approach to each project's specific context.
Exactly. That's where the expertise of a surveyor or a claims consultant really shines. They can analyze the situation, pick the right methods, and present a claim that's well supported and persuasive.
Now let's talk about the evidence itself. We've already talked about contemporary records, but what else can strengthen a contractor's case?
Aside from those daily records, the site diaries, meeting minutes, and so on, the document points out the importance of expert witness testimony.
So if there's a complex technical issue that contributed to the loss and expense, bringing in an engineering expert to provide an independent assessment could really bolster the claim.
Exactly. Their technical expertise adds credibility and provides a more objective perspective.
What about photographic evidence? I imagine that can be pretty powerful when you're trying to show the impact of delays or disruptions on site.
Absolutely. Photographs can paint a vivid picture of the extent of the delays, the disrupted workflow, even those unforeseen site conditions. They're tangible proof of the challenges the contractor faced. And we all know a picture can be worth 1,000 words, or in this case, potentially thousands of dollars.
That's a great point. And the document also reminds us that presentation matters. It's not just about having the evidence, but presenting it in a way that's clear, logical, and persuasive.
You're absolutely right. A well-structured claim document with a strong narrative backed up by solid evidence and expert analysis is much more likely to succeed than a jumbled collection of records and calculations.
It sounds like there's a real art to building a successful claim. You need to think like a lawyer, an accountant, and a storyteller all at the same time.
I couldn't agree more. It's a multifaceted process. You need an eye for detail, a deep understanding of the contract, and strong analytical and communication skills.
Now let's move on to those costs beyond the obvious, the ones that aren't immediately apparent but can have a huge impact on a contractor's bottom line.
Those are the indirect or consequential costs. Often they're harder to pinpoint, but no less real.
Can you give us a few specific examples?
Think about the loss of head office overheads. When a project's delayed or disrupted, the contractor's head office ends up spending more on things like salaries, rent utilities, and admin support. These costs aren't directly linked to a specific task on site, but are a consequence of the project running longer.
So even though those head office costs might not be visible on the project site, they're a real expense and should be included in the loss and expense claim. Does the document offer any guidance on calculating those costs?
It does. The document even mentions those Hudson and Emden formulas we talked about earlier. Those can be helpful for estimating the impact on head office overheads.
What other hidden costs should contractors be aware of?
Another significant one is the loss of profit. When a project's delayed or disrupted, the contractor might miss out on other profitable projects during that time.
It's not just about the direct costs of the delay, but also the potential earnings they miss because their resources are tied up. That could be a big deal, especially for smaller contractors with limited resources who depend on a consistent flow of projects.
Exactly, and figuring out how to quantify a lost opportunity can be tough. The document suggests that contractors can show evidence of tender opportunities they were going after during that period or their track record of winning projects.
So it's about building a case based on their past performance and showing they had a good chance of winning those lost projects.
Precisely. But it's worth noting that not all contracts let you recover lost profit. FIDI contracts, for example, usually exclude it from recoverable costs unless it's specifically allowed.
It sounds like it's crucial to check those contract clauses and understand what you can and cannot claim.
Absolutely. Failing to do that could lead to disappointment and a weaker claim.
Now let's talk about something that often causes friction: global claims.
Global claims are basically lump sum claims covering a bunch of losses and expenses without a detailed breakdown of individual costs.
So instead of itemizing every hour of labor or each increase in material costs, the contractor just submits one big figure representing their total loss.
Exactly. The document acknowledges that global claims might be okay in some situations, but it generally advises against them.
Why is that? What are the downsides?
The main issue is that global claims can seem opaque. They make it difficult for the employer to see if each cost component is valid. They can look speculative and make it harder to show a direct link between the events and the claimed losses.
So it can raise red flags and drag out disputes?
Exactly. That's why the document stresses the importance of providing a detailed cost breakdown whenever possible, clearly showing how each loss is directly linked to the event.
Transparency and strong evidence are essential for a successful claim.
I couldn't agree more.
Before we move on, I want to bring up something particularly relevant today, inflation. How does the guide address the impact of inflation on these loss and expense claims?
That's a great question, especially with rising inflation impacting material prices and labor costs. It's a huge factor to consider. The document states that if work happens later than it should have because of a relevant matter and inflation has caused costs to go up, then those inflated costs can be part of the claim as long as the contract's fluctuations clause allows for it.
So the contractor could claim for those inflated costs if the contract allows for those kinds of adjustments and the delay is directly tied to the event.
Exactly. And it highlights why having well-written contract clauses that deal with inflation adjustments is so important. It helps ensure these situations are handled fairly.
Navigating loss and expense in this unpredictable economy requires a sharp understanding of these external factors and their potential impact on costs.
Absolutely. Failing to account for those dynamics could lead to serious financial losses for both contractors and employers.
We've covered a lot of ground in this part, from the different methods of calculating loss and expense to those less obvious costs and the impact of things like global claims and inflation. What can our listener expect in the final part of our deep dive?
In the last part, we'll shift gears slightly and talk about the bigger picture. We'll explore risk management and dispute avoidance, those proactive strategies that can help prevent these situations from arising in the first place.
Sounds like we're moving from damage control to prevention, a much more strategic approach. Don't miss part 3, where we'll wrap up our deep dive into loss and expense. Welcome back to the final part of our deep dive into ascertaining loss and expense. We've been through a lot, from the ins and outs of those different contract types to those sneaky costs like disruption and prolongation.
Yeah, we've talked about why detailed record-keeping, clear communication, and presenting your claim strategically are so important when navigating this tricky area.
Absolutely.
Yeah.
Now let's take a step back and look at the bigger picture. This guide is more than just a technical manual. It gives us valuable insights into managing risk and avoiding disputes.
And what I find fascinating is that the document subtly encourages a shift in thinking.
Yeah.
Moving away from just reacting to disputes and towards a proactive culture of risk management.
So it's not just about winning those claims, but about preventing them altogether.
Exactly. It's about contractors and employers working together, being transparent and communicating openly throughout the entire project.
So what are some of the key principles for managing risk effectively in construction projects?
Well, the document highlights the importance of identifying and assessing potential risks early on.
Okay.
And going beyond the obvious. You need to spot those less apparent risks that could disrupt the project's progress or throw the budget off track.
So it's about being proactive, anticipating those problems before they become a reality.
Exactly. And once you've identified those risks, you need a clear plan to mitigate them. This might involve adjusting the project schedule, bringing in more resources, even revisiting the contract terms to allocate risks more fairly.
It's about having a safety net, a plan B for those potential pitfalls.
Precisely. And you can't just set it and forget it. You need to regularly monitor and review those risks. Things change constantly in construction, and risks can evolve over time. It's about staying alert and adapting your strategies as needed.
So effectively, managing risk isn't a one-time thing. It's an ongoing process woven into the project's DNA.
I couldn't agree more. It's about making everyone aware of those risks and creating a culture where all stakeholders communicate openly and work together.
Now let's move on to avoiding disputes. The document seems to suggest that clear communication is key to preventing those costly legal battles.
Poor communication is often at the heart of construction disputes.
Right.
Think unclear instructions, missed deadlines, changes that aren't documented.
Yeah.
These can easily escalate into full-blown claims.
So it's not just about what's written in the contract, but how information is shared and documented throughout the project.
Exactly. The document stresses the importance of clear communication channels, documenting everything and writing decisions, changes everything, and tackling potential issues head-on.
So regular meetings, quick responses to questions, and a robust system for documenting changes and approvals can really help prevent misunderstandings and disputes down the line.
Absolutely. And remember, effective communication goes beyond just sharing information. It's about actively listening and understanding the other side's perspective.
It sounds like building that foundation of respect and open dialogue can be incredibly valuable in preventing those costly conflicts.
I couldn't agree more. The document also highlights the importance of having a clear process in place for resolving disputes.
So if a disagreement pops up, there's already a plan for addressing it fairly and efficiently, potentially avoiding a long and expensive legal process.
Exactly. It could involve mediation, arbitration, or even a step-by-step process where senior management gets involved if things escalate.
Having that framework can bring some much-needed clarity and structure, especially when things get tense.
Absolutely. It shows a commitment to finding fair and efficient solutions.
So what's the takeaway for our listener? We've done a deep dive into loss and expense claims in construction. But this document reminds us that clear communication and detailed record keeping are crucial. It's not just about winning those battles, but preventing them. Something to keep in mind as you navigate those complex construction projects.
And I think that's a great point to end on. It's about shifting from a reactive mindset to a proactive one. Understanding the principles of loss and expense can empower everyone involved in a project to manage risks, communicate effectively, and ultimately work towards a more successful outcome for everyone.
That's a wrap on this deep dive. We hope you've enjoyed this exploration of ascertaining loss and expense, and that you're walking away with a better understanding of how to navigate those complexities in the world of construction contracts.